There are, very few letters that can land on your desk with that same immediate knot in your stomach kind of dread as a German Kündigung, a termination notice.
Hmm.
Even if you sort of saw it coming, the moment that physical, often very official-looking document shows up, the reality of it just hits you, especially because you realize all of a sudden you're navigating one of the most complex, deadline-driven areas of law anywhere in the world.
That's absolutely right. I mean, German employment law is famous for being protective of the employee, but that protection,
Mm.
it is not automatic at all.
Right.
It is entirely conditional on one single critical action, filing the Kündigungsschutzklage, the KSI. This is the official claim for protection against dismissal and, well, navigating its rules, its procedures, and most importantly, its razor-sharp deadlines.
Yeah.
That's the difference between keeping your job or maybe getting a good exit package versus losing everything without a fight.
And that is exactly our deep dive today. We are pulling all the crucial strategic and procedural details straight from specialized legal analysis. Our source material for this comes from a really comprehensive legal commentary provided by attorney Mr. Kiril Stawrew, who is based in Berlin, Germany.
And he focuses intensely on these critical, strategic and practical aspects of the KSI process.
Yeah.
So we're not just looking at the statutes here, we're really examining the strategy behind the litigation.
Yeah.
For employees who suddenly need to challenge a dismissal, and, for employers who need to understand exactly how much financial risk they're taking on when they issue a notice, this information is it's absolutely vital. We're extracting the essential knowledge you need to be well-informed when that clock starts ticking.
Okay, let's unpack this then. Our mission is, well, it's multifaceted, but it's crystal clear. First, we need to understand the core legal purpose of the KSEK. Second, we have to master that absolutely critical 3-week deadline and the severe consequences of missing it. Third, we'll map out the procedural steps through the labor court, focusing on the tactical negotiations. And finally, we will break down the crucial cost-benefit analysis of filing the claim. When is it actually worth fighting? This is about getting that thorough tactical knowledge quickly so you don't feel overwhelmed when you're facing German legal complexity.
So to start with the fundamentals, at its legal heart, the Kündigungsschutzklage is categorized as a Feststellungsklage.
A Feststellungsklage.
Yeah, and that translates directly as a declaratory judgment action. It's not about getting paid immediately. It's about making the court declare a specific legal fact. And this action is filed before the local labor court, the Arbeitsgericht.
So it's not immediately demanding payment or, damages. It's demanding a definitive legal statement about the contract itself.
Precisely. The core primary goal is to get a judicial declaration that the employment relationship was not legally dissolved by that specific termination notice the employer sent out. The standard legal motion, what's known as the Klagentrag, is structured to seek a finding that the employment relationship just continues, uninterrupted, with all the rights and obligations still intact.
And if that motion succeeds, the termination is basically erased.
It's deemed unworksome, ineffective, or legally invalid. And the immediate practical consequence is that the employment relationship just continues as if the termination had never even been delivered.
Wow.
This means the employee has to keep reporting to work, and just as importantly, the employer is legally obligated to keep paying the wages or the salary.
That seems straightforward, but here's where a critical legal distinction comes in that I think often confuses people who are new to this. If I win the KSHK, does that court judgment automatically order my employer to pay me all the back wages they missed while we were fighting? Is it a payment order?
And this is a really crucial point.
Yeah.
The answer is no, it is not. A successful KSHK judgment is not a Zahlungstitel.
Yeah.
It's not a payment order that you can take to a bailiff for immediate enforcement. It only establishes the existence and the continuation of the employment contract. So if the employer has already stopped paying the salary, which is, standard procedure, especially with summary for slow terminations, the employee has to take an additional procedural step.
So the KSCHK is necessary, but it's not sufficient for financial recovery. What's that second step?
The KSCHK must be explicitly expanded. You have to add what are called Zahlungsantrag, or payment motions, for the back wages. The legal term for this is Verzugslohn.
Wages due to delay.
Exactly. And this expansion is essential. It's standard practice. Without that explicit payment motion, the court judgment affirming the continuation of the contract only gets you your job back, not the money that was withheld while you were in court.
That clarifies the sequence.
Yeah.
You establish the contract is still alive, then you demand the financial performance, the back pay that's owed under that resurrected contract. Okay, now let's talk about the range of terminations this applies to. How broad is the scope of attack here?
It's universally applicable. The KHAK can be raised against virtually all forms of termination under German law. Ordinary, Fristgemasse extraordinary, also ordinarily, and even the extraordinary ones combined with a social extension period, also Frist.
Okay.
But there's a specialized wrinkle when the employer tries to terminate the existing contract and at the same time offer a new one with worse terms.
Ah, the dreaded Änderungskündigung termination with altered terms. This sounds highly complex.
It is. This scenario requires a specific form of challenge, the Änderungsschutzklage. And this involves an inherent risk for the employee, which is why the procedure is structured as a very technical two-step maneuver.
What's the risk if the employee just rejects the new terms outright?
Well, if the employee rejects the change, and the court later decides that the proposed change was socially justified, meaning the employer had a valid reason to restructure the job or cut pay, then the employee loses the entire job immediately.
Wow.
The original termination stands, and they walk away with nothing but the salary for the notice period.
That sounds like a really powerful way for an employer to intimidate an employee into accepting bad terms.
It's designed to pressure them, absolutely. And that's why the required legal maneuver is so technical. Step 1. The employee has to accept the employer's offer of the changed contract terms. But, and this is key, they must do so subject to the reservation of social justification.
A tactical acceptance.
It's a very tactical acceptance. They agree to the new contract temporarily while maintaining the legal right to challenge the change.
And what's step 2?
Step 2 is filing the Änderungsschutzklage itself. And the goal of that claim is to have the court declare that the proposed change in terms is either socially unjustified or otherwise invalid, which then forces the employer to go back to the original better contract terms. It's the only way to challenge the change legally while keeping your job throughout the process.
So the employee is essentially saying, okay, I will work under these bad terms for now, but I am going to court to prove this change was illegal, and if I win, you owe me back pay under my old contract and I get my old terms back. It's a high-stakes, very nuanced defense.
And it just shows how technical that defense has to be. If you miss that initial acceptance under reservation, you convert a manageable legal challenge into an all-or-nothing gamble on the validity of the termination itself.
All right, now let's get to the part that causes the most stress, that deadline.
Here's where we move from, legal definitions to what is really an existential threat. As critical as the content of the law is, the procedure, specifically the deadline, it just trumps everything else. The 3-week deadline is the single most critical element in German termination law.
Why is this 3-week period so absolute? Why isn't there any flexibility like we see in other areas of law, maybe tied to, when you discover the facts?
The strictness of the deadline is tied to this legal concept of Rechtssicherheit, legal certainty. The German system prioritizes getting quick clarity in employment relationships. Employers and employees, they just can't afford long periods of uncertainty about whether a contract is active or terminated.
So to achieve that quick certainty, the law imposes a pretty brutal restriction on the employee.
Exactly. Employees must file the KSCHK within 3 weeks of receiving the written termination notice. And this deadline is a procedural juggernaut. It applies to all legal arguments you might have against the validity of the termination.
All of them?
All of them. Arguments about lacking social justification, procedural errors, former mistakes, like an improper signature. If you have a legal defense, you have to raise it within 3 weeks, or you lose it forever.
Let's not mince words about the consequences here. What happens the moment 21 days and 1 hour passes?
Failure to meet the 3-week deadline is a catastrophic, permanent legal error. Section 7 of the KSCHG dictates the outcome. The termination is considered valid from the outset. Gilts von Anfang and Rechtswirksam.
Okay.
And this legal fiction is devastating because it cures all the previous legal flaws the termination might have had.
Wait, are you saying that if an employer fires me 5 days before the Works Council meeting, which is a fundamental procedural error that should make the termination invalid, and I miss the 3 weeks, the employer gets away with that procedural error completely? That seems counterintuitive to the protective spirit of the law.
It is counterintuitive, but it just reflects the priority of procedural deadlines over substantive rights in this context. The procedural negligence by you, the employee, overrides the substantive flaw by the employer.
Wow.
Let's look at that example from the source material, which really hammers this point home. The Works Council member.
The one with the highest level of statutory protection you can get.
Precisely. A Works Council member is terminated without the necessary committee consent, a major violation of their special protection. But if this employee is on a 5-week holiday and the termination letter is successfully delivered to their mailbox, the clock starts running the next day.
So the critical moment is legal access, not actually reading it.
Correct. The letter has legally accessed the employee, even if they are physically on another continent. The employer does not care that you're on a 5-week trip. If the employee comes back after 4 or 5 weeks and opens that letter, the 3-week deadline has passed, probably by at least 2 weeks.
And the termination is valid.
The termination is automatically deemed valid, and that significant statutory protection afforded to the Works Council member is entirely lost, all because they failed to file the KSEHA on time. The law offers the protection, but only if you actively claim it, immediately.
That is just brutal. It makes you responsible for arranging mail checks or ensuring someone can act on your behalf, even when you're on holiday or sick.
Indeed. But there is a narrow lifeline, and it's all about the form of the termination. The 3-week deadline only begins upon access to the written termination.
So if we see an employer getting creative, sending a termination by text message or an email or WhatsApp message.
Any termination given orally, or via electronic communication like email or WhatsApp, or without the employer's physical signature, violates the strict written form requirement under Section 623 of the BGB.
Okay.
In that case, the termination is void on its face because it's formally invalid. And crucially, the 3-week filing period for the KSEHA doesn't run at all because the legal precondition, a validly written termination, was never met.
That's fascinating. So the one time the employer's procedural mistake saves the employee is when the employer forgets that major high-stakes documents still have to be printed and signed in our digital age.
This is the ultimate legal irony of German formalism. But circling back to the written termination, what if the severe, legitimate impediment truly prevented the employee from filing? When can the court grant late admission? Nachträgliche Zulassung.
The bar for that must be set astronomically high.
It is. The court can only grant late admission if the employee was prevented from filing despite applying all reasonable care.
And reasonable care is probably where most of these motions fail.
Exactly. Courts operate under the assumption that a reasonably careful person anticipates receiving important mail. As we saw with the Works Council member, failing to have a trusted person check your mailbox during a long holiday is generally considered a failure of reasonable care.
So what are examples of things that do succeed, the really unforeseen events?
Success requires a genuine, sudden, unforeseen incapacity. So think of a sudden, critical, life-threatening medical emergency. If you're hospitalized in an ICU, you enter a coma, or you suffer a severe, unexpected mental health crisis that renders you unable to comprehend or act.
So it has to be impossible.
The key is that the event must have made arranging legal representation or filing the suit physically impossible before the deadline passed. A simple broken leg, if it happened a week before the deadline, would likely fail the test, because you could still use the telephone to contact a lawyer.
And procedurally, you can't waste any time once the impediment is resolved.
Absolutely not. The motion for late admission has to be well justified and filed within 2 weeks of the impediment being resolved, and you must submit it together with the KSEHK itself. If you miss that 2-week window after you recover, the chance is just gone. It's a tight, highly technical process.
Okay, that covers the deadline. Now let's address who actually gets the full protection of the law. We know there are thresholds for this general protection, the kind that requires a dismissal to be socially justified.
That's right. General protection against dismissal only applies if 2 criteria are met. First, the employee has to have passed the Wartezeit, the waiting period, meaning they've worked for the company for more than 6 continuous months.
And second,
the Kleinbetriebsklausel, or the small business clause, dictates that the company must employ more than 10 full-time equivalent people.
so if you don't meet either of those, you're in your 5th month, or the company has 8 employees, you lack general protection. The employer can dismiss you relatively easily as long as they stick to the notice period and the formalities.
That is correct, regarding the requirement for social justification. But, and this is the crucial insight that defines the tactical use of this claim, the existence of this general protection is not a prerequisite for filing a KSEHA. The claim is always legally permissible. It's always zulässig.
I need to push on that. Why on earth would I file a claim if the company is small or I haven't hit 6 months and the employer doesn't have to prove the dismissal was socially justified? What am I even fighting for at that point?
You are fighting to ensure the termination complies with all the other rules of the Civil Code, the BGB, which are independent of the KSCC's special protection. You're challenging the validity and the type of termination, even if you can't challenge the reason for it.
Okay, let's use an example to clarify this. What about an employee in a small business? Let's say they've worked there for 12 years, 5 employees total, no KSCC protection.
Right, so the employer issues an ordinary termination notice respecting the long notice period for 12 years of service.
If the employee files a KSCHA, they can't argue it wasn't socially justified, so what can they argue?
They can argue that the employer violated other critical procedural rules. For instance, did the employer sign the termination notice personally, or was it a manager without power of attorney? Did they consult the Works Council if one exists? If the KSCHK proves the termination failed on these formal grounds, the termination is void, and the employer has to start the process all over again. That buys you time and leverage.
Okay, now scenario 2, the short tenure. An employee in a big 500-person company is summarily dismissed, fristlos Kündigung, in their 4th month for alleged serious misconduct. They haven't completed the 6-month wait time.
In this case, the KCHK is absolutely vital. The lawsuit doesn't rely on general protection. It forces the employer to prove the legal validity of the extraordinary dismissal.
Right.
The standard for an immediate dismissal is extremely high. The employer has to prove the misconduct was so severe that continuing the employment relationship even for one more day is intolerable.
And if the court decides the misconduct wasn't severe enough for immediate dismissal, maybe it was just bad performance, not theft, the termination is invalid. What happens then?
Then the employee benefits enormously. The immediate dismissal is invalid, so they revert to their contractual status. They might only have a short notice period, maybe 4 weeks, but they still secure the salary for that notice period. And critically, they avoid the stigma and the unemployment blocking period, the skirt site, that comes with a valid summary dismissal. The KCHK, even without general protection, is about enforcing those essential contractual rights.
That makes the tactical decision much clearer. The KCHK is always necessary because it forces clarity on the legal status of the termination, no matter what protections you have.
And we should quickly address some other actions that employees might mistakenly rely on. Sometimes people reject a termination because of a lack of power of attorney, or they file a formal protest with the Works Council.
Do any of those efforts stop the 3-week clock?
Absolutely not. The KSCHK must be pursued even if you've taken those actions. Neither of them suspends or stops the 3-week filing clock. If you rely solely on those other objections, you will lose your right to challenge the termination in court.
And finally, let's lay the myth of cancellation to rest. What if an employer issues a notice, then regrets it, and sends a letter saying, "We take the termination back"? Are you legally safe then?
No. A termination is a unilateral legal act. Once it's declared, it cannot simply be legally taken out. An employer's cancellation should only be interpreted as an offer to agree on a continuation agreement.
A fortsetzung Vereinbarung.
Exactly. You should not rely on it unless you have a signed, formal agreement stating that the original notice has no legal effect and the contract continues. If you don't get that signed agreement, you must still file the KCHK to protect your rights.
Okay, so assuming you've cleared that 3-week hurdle, the process moves into the formal stages at the labor court.
It does, and this process is highly formalized to push the parties toward a resolution very quickly.
What does that timeline look like after the filing and the service are completed?
The very next critical stage is the Güteverhandlung, which is the conciliation hearing. The court aims to schedule this quickly, ideally within 2 to 4 weeks of filing, though 4 to 6 is probably more realistic.
And the timing is deliberate?
Oh, absolutely. It forces the parties to negotiate before they invest too much time and money in formal litigation.
This is a different setting than a full trial, isn't it? Tell us about the atmosphere and the tactical goals of that conciliation hearing.
It is entirely different. Critically, this hearing involves only the presiding judge, not the 2 honorary judges. And the judge's role here is not to decide the case, but really to act as a mediator.
Okay.
They'll ask both parties simple questions. What's the problem? What does the employee want? What is the employer willing to offer? The judge is trying to estimate the risk of the case going forward and will often hint at which party they think has the weaker case based on the initial filings.
So the judge might signal to the employer, your procedural arguments look a little
settlement, a Vergleich. And this is why the vast majority of cases, the sources suggest maybe 80% or even more, conclude right here.
And that settlement almost always involves what?
It almost always involves the employer paying an abfindung, a severance payment, in exchange for the employee dropping the claim and agreeing to a final termination date.
But if that conciliation fails, we move into the actual litigation, the Kammertermin.
Right, that leads to the chamber hearing. A date is set, usually 3 to 5 months later, which gives the parties plenty of time for comprehensive written arguments and rebuttals to be exchanged.
And at
Reached.
Let's talk about representation. We noted that in the first instance of labor court, there is no mandatory legal representation, no Anwaltswang. But in a process this quick and technical, why is representing yourself almost always a grave error?
Well, because the stakes are just too high and the complexity is too specialized. While you can legally represent yourself, the opposing counsel for the employer will be a specialized labor lawyer. They will use precise language, file specific motions, and structure settlements in ways a layperson just cannot effectively counter.
Yeah.
If you're negotiating a significant severance package or arguing complex rules of social justification, the investment in legal expertise will almost certainly improve your financial outcome. You need someone who can spot tactical vulnerabilities in the employer's case.
Okay, let's discuss an employer tactic that seems like a critical trap, issuing multiple notices. The nachgeschobene Kündigungen.
It is a huge trap. A pending KSCHK only challenges the first termination notice mentioned in your initial filing. So if the employer issues a second or third notice during the litigation, maybe they found new, more severe misconduct, or they just want to hedge their bets, that subsequent notice becomes automatically valid after 3 weeks if you fail to file a new KSCHK against it.
That's a ticking time bomb hidden inside your own lawsuit. What's the solution to protect yourself from this legal landmine?
The vital procedural tool is the Schleppnetzantrag. It literally means trawl net motion.
A trawlnet motion.
Yes, and this motion is filed right at the beginning, along with the original KSCHK. It's a declaratory motion that says, basically, it is declared that the employment relationship is also not dissolved by any further terminations issued by the defendant before this case is over.
So it functions as a sort of preemptive legal umbrella.
Exactly. It secures that crucial 3-week deadline for any subsequent notices the employer might issue during the months-long litigation process. Without this preemptive filing, the 3-week clock for a second termination would almost certainly pass, and that second termination would become unchallengeable.
But if you file the trawlnet motion, do you still need to update the claim when that second notice arrives?
Yes, you do. The trawlnet motion ensures the deadline is met, making the claim zulässig permissible. But to actually litigate and declare that specific second termination invalid, you have to procedurally update your claim to target that subsequent notice specifically by the time of the Kammertermin. The Schleppnetzantrag is your legal insurance that buys you the time to do that properly.
Okay, so we've established that the legal goal is job continuation, but the practical reality is often a severance payment. What is the primary source of leverage the KCHA gives the employee to force the employer to pay?
The leverage is the risk. It's the risk the employer assumes by continuing to litigate a potentially flawed termination. And that risk is quantified as the Verzugslohnrisiko, the risk of having to pay back wages.
Right.
By filing the KSCHK, you force uncertainty onto the employer. They have to proceed knowing that if they lose the case, even 18 months later, they could owe you every single euro of salary for the entire duration of the trial, plus social contributions, without having received any work in return.
That needs to be terrifyingly clear. Let's just assume a case lasts 15 months, and the sales manager from our example, who makes 3,500 EUR gross, wins. What is the financial damage to the employer?
The employer is suddenly on the hook for 15 months of gross salary. That's 52,500 euros, plus all the employer's portion of Social Security contributions on top of that.
And they got nothing for it.
Zero product from the employee for that entire period. Yet they have to pay the full cost of employment. It is this catastrophic, non-offsettable financial burden that compels the employer to offer a settlement, the Abfindung, which is a fixed, manageable cost, often just a fraction of that total Verzugslohnrisiko.
That makes the Red Lab Findung, that sort of rule of thumb of a half-month salary per year of service, that makes it look like a real bargain for the employer.
It absolutely does. The Red Lab finding is just a starting point for negotiation. but it is a much preferred outcome for the employer compared to the limitless risk of all that back pay.
So let's detail the circumstances that would really favor the employee's position and maximize their severance leverage.
Okay, first, a termination that is clearly or highly likely to be invalid due to a major procedural flaw. If the employer missed a consultation, for example, the case is very strong. Second, if the employee has genuinely poor job market prospects, this is crucial because it directly maximizes the employer's Verzugsrisiko. An older employee, or one in a highly specialized, localized role, is unlikely to find a new job quickly. This means the employer's back pay risk stays high throughout the entire court process.
And the third major favorable circumstance, which we touched on before, is the immediate dismissal.
A summary or immediate dismissal, the Fristloskundigung, is high risk, high reward for the employee. Successfully challenging it secures the continuation of salary through the normal notice period, which can be long, and protects your reputation and financial stability.
Right, because a failed summary dismissal leads to that spurt site.
Exactly, that blocking period of up to 12 weeks for unemployment benefits, because you're deemed responsible for your own job loss. The KHEK is vital for financial survival in that scenario.
Let's run the numbers on our sales manager example again, focusing on the stakes in a summary dismissal challenge.
Okay, so if the sales manager was summarily dismissed in January and their notice period ran until the end of September, the value of a successful KHK is immediate and multi-layered. They secure 9 months of salary.
Wow.
If they had an annual target bonus of, say, 25,000 EUR, the court will likely order a prorated share around 18,750 EUR to be paid out, plus compensation for any accrued unused vacation time up to September. You are looking at securing tens of thousands of euros in contractual entitlements, even before the finding negotiation even starts.
Okay, so conversely, when is a KHK less advantageous? When might an employee be better off just seeking a termination agreement and Aufhebungsvertrag right away?
Well, the circumstances are just reversed. If the termination is clearly valid, say, during the initial 6-month probationary period, or in a very small business not subject to the KHG, the employee has minimal leverage because there's no social justification requirement to overcome. The only leverage is usually the minor cost of court fees and the lawyer's time.
And what about that highly mobile employee in a shortage occupation?
This is a classic example of low leverage. If you're a highly sought-after professional, like our nurse example with 17 years of service, who was summarily dismissed for misconduct, but quickly finds a new job in a different hospital, the employer's risk just plummets.
Because of the interim earnings?
Exactly. Any wages earned at the new job, the Zwischenverdienst, have to be offset against the employer's obligation to pay back wages.
So the employer knows if the nurse quickly found an equally paying job, they might only owe a negligible amount for, say, the 2 weeks between jobs, even if they lose the case a year later.
Precisely. This drastically reduces the employer's Verzugsrisiko, which in turn weakens the employee's negotiating position for a high severance. The employer might just calculate, my maximum loss is minimal, so I will offer a low settlement or none at all.
This brings up a critical tactical question that must cross every employee's mind. If I know my employer's leverage decreases the moment I find a new job, should my lawyer advise me not to search for a new job immediately to maximize the employer's risk? Is that ethical or is that legally risky?
And that is where the legal reality of German law introduces the concept of Schadensminderungspflicht, the duty to mitigate loss. While there's no criminal penalty for being unemployed, you have a duty under law to avoid unnecessary financial loss, and that includes actively seeking alternative employment, especially if the new job is comparable to the old one. If the employer can successfully argue that you failed to meet your duty to mitigate loss, for instance, by showing you turned down multiple comparable job offers, you might lose your claim to a portion of the Verzugslohn.
So tactically, you can't just sit idle and rely solely on the employer's back pay risk. You have to be seen to be seeking work, even if the real goal is a settlement.
Yes. Your lawyer has to advise you to look for work to protect your legal position on Verzugslohn. But in practice, both parties understand the inherent conflict. The employer fears the potential risk of back pay if the employee doesn't find a job, and that fear is the leverage, regardless of the duty to mitigate.
Final thought on strategy here. It is legally permissible to file a KSCHK solely to negotiate a severance package, even if you're ready to move on, correct?
Absolutely. This is the single most common reason the KSCHK is filed. The official legal goal is job continuation, but the dominant practical goal is forcing the employer into a favorable financial separation.
And what about forced dissolution? Can an employee ever force the court to order a severance payment if the termination was invalid, but the employer absolutely refuses to settle?
Only in extremely rare, exceptional cases. This is a motion for forced dissolution. It requires the employee to prove two things. The termination was invalid, and that continued employment is intolerable for some pressing reason.
And the bar for that is high.
Extremely high. It usually requires documented hostility, like the employer making denigrating or legally false accusations that make future cooperation impossible. Courts are very hesitant to grant this motion. The standard legal assumption is that most conflicts can be resolved and employment can continue.
Okay, we spent a lot of time on the offense, the employee's strategy. Now let's analyze the defense. We are shifting gears to what the legal analysis from Mr. Stawrew highlights as the most common and costly strategic errors that employers make.
The first mistake is a fundamental one of timing. Before the termination notice even leaves the office, employers should always check if a mutual termination agreement and Aufhebungsvertrag is the better alternative.
To avoid the fight altogether.
It eliminates the uncertainty, the Verzugslandrisiko, the time, the stress of a potential case entirely. A well-negotiated mutual agreement, often with a modest severance, is a guaranteed clean break, which is often priceless for managerial peace of mind.
But if they move past that and issue the notice, and then they find themselves in that Güterverhandlung where the judge is raising an eyebrow at their paperwork, what's the mistake that happens next?
The second major mistake is about hedging, missing opportunities for subsequent terminations. If the employer realizes the first notice is vulnerable, maybe the judge hints at a procedural error, or the employee's lawyer brings up new evidence, the employer must immediately investigate whether new grounds exist and issue additional nachgeschobene Kündigungen right away.
Why is that investigation and that immediate second notice so vital?
Because if the employer waits until the Kammertermin 3 months later, they might discover the new grounds too late. Or worse, they might have let the 3-week deadline for the second termination pass while they were focused on the first.
So they are left exposed.
Completely. Failing to secure the dismissal with further stronger notices is a significant error. If the employer loses the KCHK on the first notice, they are stuck with the employee, maybe indefinitely, if they fail to properly launch a second, valid termination.
The third mistake seems to be about information asymmetry during settlement talks. Employers often fail to minimize their risk proactively.
Exactly. Employers have to actively work to reduce their exposure to that Verzugslandrisiko. By the time of the Kammertermin, they must formally ask the employee if they have found a new job. They have to confirm the existence of Zwischenverdienst.
Why is that question so tactically crucial?
If the employee admits they've secured new employment at a comparable salary, the employer's risk of having to pay massive back wages is instantly neutralized. That information instantly shifts the power dynamics in the negotiation. It significantly weakens the employee's leverage for a high severance package. If the employer fails to ask, they're negotiating blind against their own worst-case scenario.
And what if the employee just refuses to answer the question?
Well, while the employee isn't forced to disclose this information outside of specific court orders, the silence itself often provides a strong signal. A confident employee with no Zwischenverdienst will often use that fact as leverage. An employee who refuses to answer is likely concealing new income, and that allows the employer to negotiate with a bit more certainty that their risk is actually lower. And the fourth classic employer error is purely relational and tactical, a failure to signal flexibility.
What does that even mean in the middle of a lawsuit?
Many employees, especially highly skilled ones, file the KSCHK purely as a protective measure to get a finding and a clean break, but they've already mentally checked out. They don't actually want to return.
Sure.
So if an employer is willing to walk back the termination, effectively offering a continuation agreement if the employee drops the suit, they should signal this clearly. This openness often helps contain severance demands. If the employee knows they can simply return to their job, their demands for a high lump sum severance often decrease. It's about offering an alternative resolution.
Okay, we cannot complete a deep dive into litigation without talking about money, the financial architecture. German labor court costs are structured to be employee-friendly in the first instance. Let's start with the official court fees, the Gerichtsgebühren.
Court fees in labor courts are generally remarkably low compared to civil courts dealing with similar financial sums, and critically, the client, which is usually the employee, does not have to pay these fees in advance. This lowers the initial financial barrier to asserting your rights significantly.
And since, as you said, 80% of cases settle in that conciliation hearing, what happens to those fees?
If the case is resolved by a settlement, a vergleich, or it's withdrawn before the main hearing, court costs often disappear completely. They're often canceled or reduced, making them practically negligible in the decision to file a claim. The system is explicitly structured to avoid making court fees an obstacle.
That significantly reduces the initial financial risk. But this raises the big question about the bigger expense: attorney fees. This is a point of significant departure from, say, the US or UK system. If I win the case, does the employer have to pay my lawyer?
This is the most unique and crucial feature of the German labor court system in the first instance. The rule is absolute. In the first instance of a labor court proceeding, regardless of who wins or loses, neither party has a claim for reimbursement of their attorney costs.
Neither party. So even if the court rules the termination was invalid and I win completely, I still pay my lawyer, and the employer still pays their lawyer.
Exactly. And the legislature created this rule with a clear purpose: to relieve the employee, who's typically the financially weaker party, of the potentially ruinous risk of having to pay the employer's substantial legal fees if they lose the case.
So it's a trade-off.
It's a trade-off necessary for access to justice, but it means that even a successful litigant has to account for their own legal expenses.
That makes the cost calculation vital. How are those fixed attorney fees set by the Rechtsanwaltsvergütungsgesetz, the RVG, how are they actually calculated?
They're calculated based on the Streitwert, the official value in dispute, and for a standard KCHK, the universally accepted Streitwert is set at 3 monthly gross salaries representing a quarter's earnings. That figure determines the baseline for all the fees.
Let's run a detailed example using the source materials calculation. Say the employee earns 3,500 EUR gross monthly, plus a full 13th month salary annually.
Okay, so the Streitwert calculation accounts for that 13th salary. It's 3,500 euros times 13 months divided by 4 to get 1 quarter, resulting in a total Streitwert of 11,375 EUR. And that figure then defines the bracket for the attorney fees.
And if the case settles in that crucial Güterverhandlung, how many fees does the attorney charge?
The lawyer typically earns 3.5 fees based on that Streitwert: a 1.3 procedural fee for filing, a 1.2 term fee for attending the hearing, and a 1.0 settlement fee for the successful comparison. Based on that 11,375 EUR value, the total costs, including the flat rate and VAT, are calculated to be around 2,797.69 EUR.
So an investment of just under 2,800 euros. And we saw earlier that this investment could secure a sales manager nearly 20,000 euros in notice period salary and pro rata bonus, plus potentially tens of thousands in severance. That is an extremely potent investment.
It is often the best money you will spend. The attorney costs are highly justifiable because they convert your weak individual position into substantial legal leverage, securing a financial outcome that far exceeds that initial investment.
And for those who are facing this without the immediate means to cover that 2,800 euro investment, what funding options exist?
There are 3 main safety nets in Germany. First, union membership Gewerkschaftsmitgliedschaft often includes free legal representation. Second, legal insurance Rechtsschutzversicherung covers the attorney costs. And third, for those financially unable, state legal aid, or Prozesskostenhilfe, is available, provided the case has a reasonable chance of success, which a timely filed KCHK usually does.
This has been an intensive and I think really necessary deep dive into the German Kündigungsschutzklage, focusing on the procedural pitfalls and the strategic leverage it provides.
Let's quickly summarize the 3 non-negotiable takeaways. 1, the 3-week deadline is the sword of Damocles. You miss it, and any legal defect in the termination is automatically cured.
Right.
2, the claim is always favorable severance package.
We focused heavily on the mechanics of the KSCK, but if we connect this to the bigger picture, the entire legal architecture of the labor court system seems structured to avoid these drawn-out confrontations.
It is. That quick, mandatory Güterverhandlung and the first instance cost rules are designed to push both parties away from legal warfare and toward a mutually accepted compromise, be that severance or a continuation agreement. It's a system designed to encourage negotiation, not protracted,
stands out to you? If the goal of the Kündigungsschutzklage is legally declared as the continuation of the employment relationship, yet it most frequently results in a lucrative severance agreement, does the true objective of the German legal process in this area fundamentally shift from protecting the job to protecting the employee's financial future? Something to consider as you navigate the complexities of labor law.